Welcome to the Mean Lady Talking Podcast. This is the podcast that tackles tough questions about relationships, life, love, and loss. It may not be the advice you want, but is probably the advice you need. And now here's your host, grief therapist, motivational speaker, relationship expert, best-selling author, and attorney, the not really mean lady herself, Susan J. Elliott.
Good day, everybody. This is Susan Elliott, host of the Mean Lady Talking Podcast, and today we are going to do the third in a 5-part series of navigating the legal system with the personality disordered. This is when you have to go through a divorce, or you have to co-parent, or you have to go back to court for custody visitation. Maybe your family is involved with a parenting coordinator or a CPS or some other entity, but you are what is called a high conflict family in the legal system. As a former psychiatric clinician and as an attorney, I have seen the interaction between these entities, the legal entities, the mental health professionals, and it is very difficult when your co-parent is out of control due to a personality disorder or just being so completely dysfunctional, irrational, not willing to really work on having a good and healthy life and not putting the best interests of your children first. I've seen this over and over again, and I know that it's very difficult when you don't have a personality disorder and you don't want to be in and out of court all the time. And as I have mentioned on one of the earlier podcasts and in articles that I've written on this, you cannot imagine why somebody would want to be dragging you in and out of court, in and out of parenting coordinators' offices, in and out of CPS. You just don't get it because you're not disordered. I've been studying this for a few years now as both a therapist and as a legal professional, as an attorney, and this year my last boot camp of the year is going to be navigating the legal system with the personality disordered. I've spent more than a year researching this, and because we have 50 states and all of them seem to be different and handling high conflict parents differently, I've wanted to get a good handle and not just paint everybody with the same broad brush that we use in New York. And I've also looked at it in other countries. I mean, Canada is very similar. In the United Kingdom is very similar. So I have a pretty good grasp about this, and I will be writing a book on this. But first, I'm going to be doing the boot camp. So if you are interested in the boot camp, please let me know because it's half sold out already, and it doesn't start until the first week of October because it's going to be a 12-week boot camp, and I wanted to make sure we got through the holidays with the support of the boot camp. So if you're interested in that, please send me an email immediately. If you have any questions that you want answered, please send me email as well, even if you're not interested in the boot camp, and I will try to get it on a future podcast. One of the things that I talk about in the other two podcasts that I've done in this series is that as tempting as it is for you to argue with the personality disorder co-parent, it's very important that you don't. And I've given examples about how they could just drive you completely to distraction and not give you a break. And the next thing you know, you're like screaming at them or sending them the nastiest emails or texts that you could possibly come up with. They tend to harass you. And I understand that. And they think they're being good parents, or they think that there's something that they're doing in the best interest of their child. But many states have what's called a child-friendly statute, which basically means, in some places called parent-friendly statute, some is called child-friendly statute. What it means is you don't pick fights with your co-parent because that's not in the best interest of your child. It's not good to call them names, even if your child doesn't ever hear the names. The best interest of your child is served when parents are not clashing all the time. Personality disorder people do not get that, and they don't particularly care. Harassing the parent of your child is never in the best interest of your child. And if somebody cannot understand that, they're not fit to be a parent. You must love your children more than you hate your ex. But someone with personality disorder, and from here on in, I'm going to call them the PD for brevity's sake, otherwise this podcast can be 3 hours long, the PD cannot grasp that simple concept because love has nothing to do with their senseless and ceaseless diatribes. Because you're not disordered, you cannot imagine how the PD thinks because you're normal. And thank goodness you escaped a lifetime of living with this lunacy. But you still have to deal with the gigantic wad of goo that appears to have infected your feet and your brain whenever you try to deal with this person. It's a never-ending battle. And that is why legal professionals and some mental health professionals label these high-conflict families. It's hard, in the face of what the PD is saying, not to explode in a string of expletives most of the time. Even the most mild-mannered non-PD can be tweaked to the point of losing it. And that's exactly what the PD wants. The PD is very experienced in being a master manipulator. Do not argue with one. That's exactly what they want. Ignore, ignore, ignore. It is essential that you construct as many boundaries as possible as to time, manner, and content of communication. I talked about this in the last podcast in this series, that you really want to confine everything to email. Professionals who are assigned to combative couples or high conflict families must learn to recognize when one person is trying to up the ante. Unfortunately, when the PD is stopped at just about any juncture, they have more stops on the manipulation train. Usually when one tactic works to stifle the PD, they increase the barrage by introducing new unfamiliar people to the scene, such as teachers, churches, doctors, or child protective services. They try to enlist the aid of more outsiders when the usual outsiders start to grasp the reality of what's really happening in this troubled dynamic. A PD will subject the children to investigation and scrutiny of CPS and other professionals where no abuse or neglect exists on the part of the non-PD parent. The PD will instigate needless and traumatizing investigations and examinations by social workers, doctors, nurses, and therapists. They're on a crusade to destroy the non-PD, and to subject the children to senseless disruption is part of the crusade. And the absolute scariest part of this is that they see nothing wrong with it. The public is told whenever a child is hurt by a parent and CPS has been involved that the caseworkers are overloaded. And part of their overload tends to be senseless reports that they have to deal with from vindictive and vengeful people. And it's not just always co-parents. Sometimes it could be a landlord, a tenant, another relative, a friend. But people think, for some twisted, crazy reason, oh, I know what, I'll call CPS on them and I'll tell them that they have and I will get back at them, without realizing that they are taking away CPS coworkers from the children who are being abused, who do need attention, who are being neglected, and do need somebody to come and take them out of difficult situations. There are not endless resources in CPS. Anybody who uses any part of the legal system or the child protective system to report false abuse are taking resources away from people who are actually being abused, who actually need it. And that is horrible, and it's wrong, and it's not okay. So these people wind up harming children they don't even know. And that's part of the outrageousness that has to be seen for what it is. Abuse of the system, abuse of the non-abusing parent, and abuse of the children who actually need the help of CPS. Making false reports either to police or to CPS is a crime in most states. The problem is that so many people who have been accused of false things are so worn out they don't pursue it. And these are the things that the person making the report banks on. And if the person's personality disordered, they bank on it even more. It's a terrible thing when someone wastes the resources that need to be spent on children and families who really need the help of the authorities. Please fight any unfair charges by CPS and file abuse of process and false CPS claims when possible. These people must be stopped. It's not okay, whether it's your co-parent, if it's your neighbor, it's your landlord, it's your tenant, whoever it is. They need to be stopped. I've actually had non-PD parents tell me that they were glad that CPS was involved because then CPS could take a look at the PD parent, and many times it might backfire on them, but the road to that point is very long. And CPS and the police should always look for litigious parents. These are parents that will take the other parent to court over anything and everything. They love being in court. And I've said this on another podcast. I'm an attorney. And unless I'm in court as an attorney, I don't like being in court. But as both an attorney and a mental health professional, I can tell you that only disordered people love being in court. And they lie, and they lie, and they lie, and they lie. They lie to the police. They lie to CPS. They lie to housing court. They lie to everybody. They lie in civil court. They lie in criminal court. They lie all over the place. A good therapist, a good CPS worker, a good lawyer, a good judge will have staff that keep an eye out for multiple cases, and they will bring it to the attention of whatever forum they're in. Look, this person is fighting this in this court. This person's fighting that in that court. They're fighting their landlord over here. They're fighting me over there. They're fighting their ex-wife over there. They're in court all the time. And PDs know when their back is against the wall and somebody calls bullshit on their charade, they will scream abuse. They will say they were never served. They will say someone else is to blame. It goes on and on and on. In different forms, different courts, different judges. Someone needs to pull the pieces together. And if it's you, you need to do that. Most court system cases are available for the public to see. A PD knows that most of the time, no one's watching all the different courts, all the different forums. They bank on the fact that no one's seeing their total disregard for the entire system. And they have such disregard for the system because they're playing it, and they're playing it well. So the system, all of them who are involved in this game and not looking to see where else litigation is taking place and exactly what's going on and what excuses are being used, they're being played. And then the PD thinks they're smarter than everyone. They know the game. They know how to play it. None of you can game them because they're better at game playing than everyone else put together. And unfortunately, I've seen so many therapists and so many parenting coordinators, so many judges be completely owned by these people. They get away with so much for so long because the system sees them as normal and they're anything but. But if one person stopped and gathered up all the professionals they're working with and all the different stories they've been told and all the many lies that have been told and how many people have been blamed, even the most clueless person should be able to see it. Aha! This is a user. This is an abuser. This is a person who's taking advantage of the fact that all these different forums, all these different lawyers, all these different judges are not talking to each other. They do things to shame others. They accuse people of abuse, sexual abuse, stealing, lying, cheating, so many things that no one wants to go to war over it because it's embarrassing. But they lie to so many over so much, and they need to be stopped. A good lawyer with a non-PD client should be able to track down all the stories, all the dockets, all the excuses, all the lies, all the judges, all the parenting coordinators, all the CPS workers, and they should all be taking this seriously. And they need to do something, and they need to do something fast. As I have talked about in previous podcasts, the system is painfully slow. It could be months and months and months before you get in front of a judge. Then you find yourself in front of a judge who knows nothing about the case. All of a sudden, your judge is on vacation, and your judge you think was kind of getting wise to the PD and wasn't really falling for all the lies and nonsense. And then all of a sudden, you wind up in court one day, and it's a new judge who's giving that person the benefit of the doubt. And you feel crushed, and you're like, oh my God, I'm going to lose again. even if the personality disordered parent does not take it so far as CPS, they suck up all the resources whenever they can. One of my clients had a PD co-parent who joined a church, even though he had never attended any church in his entire life. Never mentioned going to church. They had been married for 9 years. She said that he never once mentioned praying or God or anything. But after only a few months in the church, he enlisted the help of his well-meaning but unskilled minister who believed every lie the PD told. And the minister encouraged the PD to file motion after motion after motion for full custody, even though those motions had failed. But now he had enlisted the help of the clergy. But the PD's attorney, his own attorney, was beginning to understand what was going on and bowed out of the case. A new attorney comes along. Why? Because the minister lent this guy enough money for a retainer of a new lawyer. And the new lawyer was convinced that his client had been wronged, and now it was off to the races once again. And the non-personality disordered co-parent was completely flabbergasted. The motion for change of custody came, and she was like, we've already been through this. What is this all about? She could not believe that they were there again. The minister, who had no contact with the family prior to the divorce, testified as to the virtuous nature of the PD and the despicable and evil nature of the non-PD. Over her lawyer's objections, the minister detailed several incidents that never even happened. And because it was clergy, the judge gave them wide berth. And so the minister goes on to describe the PD as upset to the point where the minister had to counsel him for hours in his distress and concern for his children. And something had to be done. And as incredulous as it all seemed to those of us who were versed in the rules of evidence, the judge allowed the minister to recite chapter and verse of the PD's plight and the non-PD's questionable character. And this sort of grandstanding should never be allowed in child custody hearings. Never. Especially when custody had already been put to trial and already had been decided. But PDs are master manipulators at pulling people into this sphere and recruiting them to fight in their crusade. There was another story of another client who did a little bit better. When the PDX cried to the judge that she could not bear to subject her children to her ex's ruthlessness, and that he would only back off from corporal punishment when she reminded him of the times he went too far during their marriage, the man had never gone too far. There had not been any allegations of abuse to her or the children during the marriage or during the divorce. But as soon as he wanted more parenting time, she filed for a restraining order based on an assault that allegedly happened the night before. So when they went to court for a hearing in criminal court to turn the temporary restraining order into a permanent one, he presented evidence that at the time of the alleged assault, he was on a plane 35,000 feet in the air. He had left her a voicemail that he was going to be out of town, but she typically deleted his emails and voicemails and would later claim he was lying about sending them. At one point, his attorney attempted to get a forensic analysis of her computer to find the deleted emails, but the judge denied it. I mean, that will go on in a criminal case and a murder case, but it's not really going to go on in a civil case or just a restraining order case. So she continued to delete his emails and his voicemails the minute they came. But this time it came back to haunt her. Had she read it and known that he was on a plane, she would have constructed her story a bit differently. She not only lost the restraining order hearing, but the judge wrote to the family court judge and said that she needed oversight. But PDs do not give up their narratives very easily. They're convinced they're smarter than the rest of the world, and this woman was no different. Despite being revealed as a liar, she claimed that she was merely confused from so many hits in the head by her ex. It was just a complete train wreck. She refused to back away from her story. She continued to maintain that he was abusive to her and the children throughout the marriage and continued to try to use it as leverage throughout the divorce and the custody hearing. She also emailed him long, lengthy, accusing, inflammatory emails detailing hosts of episodes that had never happened. But he printed them all and presented them to the judge. After reading through them, the judge came down hard on her. And he said she was harming all the actual victims of domestic violence with her pretense. And if she accused him one more time of these made-up assaults, he was going to penalize her. The judge went on record to say that when courts encourage email communication, it's to document exchanges between two people who cannot agree on parenting. Therefore, said the judge, there must be parameters around it. He said if she continued to maintain that he wasn't sending emails, he would order a forensic examination of her computer. At the same time, he told her her emails needed to be brief and to the point, which is advice I give my clients, whether they're involved with a personality disorder person or not. Brief and businesslike, and only very, very necessary. There's so many things you don't have to talk about. But if you absolutely have to talk about things, brief and businesslike. And the judge said there had to be a point to the emails, not just useless ramblings. However, I have met so many judges who leave orders too ambiguous, too open, or try to lean too heavily toward the PD. You cannot give families meaningless orders. The PD will pounce on that and give the meaning he or she wants it to have. If you have an attorney and your attorney shows you an order and the order is so vague or leaves open a whole wide berth for the PD to operate in, you have to ask your attorney to ask for clarification from the court. I have seen PDs pull so much out of vague orders that they have the next judge's head spinning, or the parenting coordinator, or the CPS worker, or the therapist, whoever it is, because they're going, I don't know. I mean, it's a parenting coordinator, it's a CPS worker, it's a therapist. They're not lawyers. They're going, I don't know what it means. This is a judge. I don't know what it means. He says it means this. Okay, fine. But judges have to make their orders clear and concise. And if it's not clear and concise, if it looks like there's loopholes for the PD to jump through, you have to talk to your lawyer. You have to say, we need clarification on this because this, and this is what this person's going to do, and that's unacceptable. And then the PD will be running the show. And that needs to stop. As I talked about in the first 2 episodes of this series, most divorced couples are not co-parenting in an optimal way, but they manage to do it without the involvement of a whole bunch of third parties. Those who need third parties cannot be left week after week to their own devices. There has to be clear limits and boundaries, and they have to be set for these parents more than others. A constant flow of email is unnecessary. You should not be changing visitation. You should not be changing regular happenings. Everything should run smoothly. Constant email should be unnecessary. If you're upholding your end of custody support and visitation, you never have to talk about it. You just do it. You might do it with resentment, you might do it unhappily, but you do it. The welfare of children who have one personality disorder parent depends upon the ability of a parenting coordinator, a social worker, or a judge to quash the PD's manipulation. If you are represented by an attorney, ask your attorney to make a motion laying out the exact parameters of email and communication. If your ex uses exchanges to harass you, to insult you, to call you names, make a motion to have the exchange take place at the police station or a well-traveled location such as a mini mall. Look into getting a dash cam so that you can record the exchange. If you're self-represented, talk to attorneys who work for the court system. Some states have family law coordinators, and I worked for one when I was in law school in California. They're very, very good family law facilitators in any county courthouse in California. And if there's not one in your county, there's one in a nearby county. And ask them to help you draft and file motions. What kind of motions? If there's a parenting plan in place and a parenting coordinator assigned, the parenting coordinator needs to recognize that clear parameters for communication have to be drafted and followed. And I talked in one of the other podcasts about how I had to jump down the throat of a parenting coordinator who didn't think that this guy's emails were abusive, and they were absolutely abusive. And I said to him, you're in the wrong field if you don't think that this is abusive. 3 years after a divorce is final, you should not still be calling your ex name, accusing them, oh, you cheated on me. All of that is water under the bridge. All you need to do right now is be a good and healthy parent to your kids. And if you're insulting the parent and getting them upset, that's not good for your kids. I don't care. I don't care if the kids never hear the insult or the names that you just flung at your co-parent. The co-parent's going to be upset, and that is going to affect your children. And parenting coordinators must understand that giving a PD unfettered email access to the other parent is like giving an arsonist a match. They never stop. There must be some time and subject limitations on email. Email must be contained to important information only. They must be limited to a number per week and limited to a word count per email. For example, email on Tuesdays and Thursdays only when something is pressing, such as a schedule change, a school event, financial obligation due, something like that. Email is restricted to 5 sentences max and with information only. No opinions, no insults, no rehashing of past issues, incidents, barbs, etc. There must be no recounting of stories by the children. My daughter told me that you blah, blah, blah. No personal attacks or accusations. No rehashing of the past. There has to be clear off-limit topic, and they need to be drafted so there's no mistake as to what is and what is not off topic. Other people are off limits. Other stepchildren, new love interests, ex-in-laws, friends, etc. None of that. None of that should ever be in an email between co-parents. The co-parent should keep clear records as to the amount of text, emails, phone calls, and letters, so that if a new party is brought in, such as CPS or a doctor or a teacher or someone else, the history of the communication should be readily available for them to understand the dynamics and the history of the parties. And there must not be any communication regarding anything but the children and their tangible needs, such as schedules, school, and finances. Parenting coordinators should discuss how you handle disagreements. For example, if the coordinator can draft clear guidelines for certain situations, such as if a parent fails to uphold their responsibility, the other parent should note it in an email in a non-accusatory way. And like I've talked about in other podcasts, use I language, such as, I noticed that you have not paid your half of the day camp bill. I'll pay it if you agree to reimburse me by July 1st. If there's no answer or an insulting barrage coming back, the parent should simply repeat the request and ignore everything else. On the third time, the parent should say, look, I'm going to pay the bill and I would appreciate reimbursement by July 1st. If I do not have the reimbursement, I will file for reimbursement through the court. And most of the time, this stuff is spelled out in child support agreements, and technically it's contempt of court, but don't label it contempt of court. Don't say I'm going to file for contempt of court charges against you. Just say, I will file for reimbursement through the court. By crafting clear, well-defined procedures for dealing with violations of court orders, the parenting coordinator can help everyone focus on the task at hand, which is the support and care of the children. The parenting coordinator should lay down the rules that there is to be no communication except in written form unless it's an emergency. And like I talked before about doing child exchanges in a public place, it's very important. If one parent uses child exchange to harass the other, the exchange should take place at a police station or video recorded by third parties. I had a parenting coordinator say to me that they thought that the exchange at a police station was too much, that it was going to scare the children. The children weren't even wrapping their brains around it being the police station, and to them, the police were people that protected you. They weren't scared. But the PD complained to the parenting coordinator, and then the parenting coordinator suddenly had a problem with the police station exchange. Children don't need to know that you're in the parking lot of a police station. If that doesn't work, get a public place such as a strip mall where others are around and no one will be subjected to harassment. Don't let people be manipulated into a secretive exchange where the PD is going to be able to go off. If the parenting coordinator monitors all emails and if there's any violations of the rules, the violating parent is notified that continuation of the violation may bring a contempt of court charge. Now, I said you shouldn't be threatening contempt of court because that can be very inflammatory language and set the PD off. So if you're the parent, you could just say, I'll have the court deal with it. I'll file for reimbursement through the court. But a parenting coordinator can say, if you continue to violate the clear guidelines for communication, we will file a contempt motion. And parents, through parenting coordinators, all parenting coordinators should encourage parents to not make conclusory allegations such as your failure to comply with the parenting plan shows a lack of concern for our children. All conclusions need to be drawn by the parenting team and not either of the parents. If a person cannot follow a parenting plan, a judge should look for alternatives such as anger management, parenting classes, therapy, or a change in custody and visitation. But the courts must limit the time, money, and energy that PDs take up and get them help or figure out a way to suppress their dysfunctional acting out. Professionals should be more inclined to penalize those who abuse the system, whether it's the parenting coordinator, the courts, or social services. There must be some penalty for the senseless waste of resources. As I said earlier, check the dockets. Check family court, housing court, traffic court, criminal court. Follow the PD through the system and let each judge and opposing side to the PD know what else the PD has going on. PDs leave lots of charred bodies in their wake, and chances are the bodies don't know about each other. Keep a reminder to yourself to check the dockets once a month. Most are available on public websites. Look for rescheduling because the PD didn't receive an order. They're always yelling that they didn't receive notice, and then they get an extension. And if their landlord's trying to evict them, they get to stay there a little while longer. So they're constantly playing games. And they play the same games in different courts. So you just need to show somebody that there is a pattern of abuse here. Look for these reschedulings. Contact the opposing attorney and let them know how many times the PD has pulled that on you. Judges like to know about litigious people. Let them know how many courts, how many forums, how many agencies the PD is appearing in, how many different inflammatory charges they're making, how many people they're fighting with. Show the judge how much time is being taken up with this one person. Show the judge the inordinate amount of times the PD just happened to not get served. They're always didn't have notice. But judges listen to that kind of information. If 4 or 5 people are trying to serve them and none of them are getting through, something's going on. Clue in the attorneys and they will clue in the judges. And remember that the whole idea of any parenting plan, any custody order, any visitation order, any support order, at the very heart of it is the best interest of the children, the well-being of the children, the welfare of the children. The PD uses the children as excuses to sidestep healthy boundaries and to pound on the table with the children's welfare in mind when the way they're behaving shows that they don't care at all about the children's welfare. If they did, they wouldn't be accusing everyone of everything. And they will say things in email. I only care what your neglect does to the children. They use conclusory language to tarnish the image of their co-parent. They only see the ex as a culprit and never feel anything but obligated to point this out. They want to make it sound like they're the long-suffering victim and they're the hero of the children. They're just telling everybody what they need to know. but their mission has nothing to do with the welfare of the children, because if it did, they wouldn't be continuously dragging their ex into court or sending all of these inflammatory emails. Their mission has nothing to do with the kids. It's to make their ex pay for whatever perceived sins and slights have been committed over the course of their relationship. And there's no relief in sight if the courts and the parenting teams don't assist in making it stop. Professionals who are tasked with interfering and intervening in situations that involve a personality disordered person have their work cut out for them. And a lot of times, and I've been saying this as a therapist, as a former psychiatric clinician, and as an attorney, I can see it. I can see their eyes glaze over, whether it's a legal professional, a mental health professional, because they don't know how to talk the language of both places. The mental health professionals don't know how to talk legalese, and the legal professionals don't know how to talk in terms of personality disorder. So they become very muddled. They become very confused. But as somebody who has worked in both systems, I can see that. But they have to get smart about these things. They have to say, okay, well, maybe I don't know if this is a personality disorder, but I know that this behavior is not okay. They need to know that. They need to cop to that, and they need to do something about that. Professionals, whether legal or mental health, who are tasked with intervening in these situations have their work cut out for them. Yes, I know. But if you have a clear plan in place, it can be done, and it can be done to protect the best interest and the well-being and the welfare of the children. And it's very important. Very, very, very important that legal professionals and mental health professionals do exactly that. And whether or not you're in a co-parenting situation with a PD or you know somebody who is, any kind of retaliatory reports of abuse or child neglect that goes to the police, goes to CPS, that is absolutely wrong. It's a crime in most states, and you should report it. Now, that is the third in a 5-part series. And in number 4, I'll continue with more tips and hints of how to deal with the legal system, with the mental health system, and with the personality disorder. I have a few more hints and tips and tools. But in the meantime, send me email, meanladytalkingpodcast@gmail.com, and I will work into the next 2 podcasts. And we have a Facebook group, Navigating the Legal System with the Personality Disorder. Please join us there. If you want to join the boot camp, you could do that. If you want more information on anything, just send me email and I will talk to you. And if you're involved with a personality disorder co-parent, I feel sorry for you. I'm really sorry, but there are tools, there are ways to get around it. And I hope you continue to listen. Thanks a lot, all. Take care. Bye-bye.